Thank you all for coming along today. It's great to see so many people interested in today's webinar with over 420 registrations for today, and a lot of people already joined us so far. Before we get started, I do just want to say with me, I do have Lauren Smith from Clayton, who is a senior associate from the Environment and Sustainable Development Group at Clayton. And so she was one of the lawyers involved in part of a legislation review done for the WSUD Maintenance Compliance Framework, which is a project I and some others have been working on for over a year. So I'll be touching on that soon. Before we get started, I also would just like to begin by acknowledging the traditional owners of the land we are all on today and the continuous connection to land and sea. I would like to also pay my respects to elders past and present. Before we go any further, I also do just want to put two disclaimers here. Firstly, the information within this presentation is being provided as general information only and is not to be relied upon as legal advice, but also just acknowledging that Ocean Protect, the company I work for, does have a conflict of interest in relation to the topic of improving WSUD maintenance, noting we supply, install, and maintain WSUD assets. Before we go any further as well, just want to put, if you have any questions, you can submit them through the Q&A panel, part of the Q&A panel that Zoom has, and we'll answer them at the end of the presentation. If you're interested in getting access to the slides and recording from today's webinar or sharing that with someone else, you can do that via the Ocean Protect website. And if you're looking to get CPD, you can send your form requests via inquiries@oceanprotect.com.au. So now just a quick overview of how today's presentation is going to be going. I'll talk a little bit about the WSUD Maintenance Compliance Framework, then going into a bit about the review that Lauren Smith was part of and other members of her team, and then going into the actual law around WSUD asset maintenance. So for those of you that haven't heard about it, for over the past year, Ocean Protect and a bunch of other individuals and organizations have been working on a project called the WSUD Maintenance Compliance Framework, which is a free package of information, resources, and tools that councils can use to implement and manage WSUD systems within their jurisdiction. And so there's many components to this, with one of them being the actual legislation review and summarizing that within the guideline that forms part of this framework. And so today's webinar is going to be focusing on some of the findings from that review. Now, before we get into the review, just to clarify that for context, that this is the review was done for Queensland, New South Wales, and Victoria. So it doesn't cover all of Australia. However, it does provide a good starting point for kind of what it could be like for across Australia. And the question, so basically for that review, I approached Clayton with a bunch of questions, and then they did the work, did the review, and then provided responses to that. And so for today's purposes, I've condensed those questions into three, which are on the screen right now. Is it illegal for an asset owner not to maintain their WSUD system? So that's private and public WSUD systems. Is it illegal for councils not to enforce maintenance requirements on private WSUD systems? And then are there mechanisms that can be used to allow councils to require certain things to be done during and post-development projects with WSUD systems? So I'll hand it over to Lauren now and get started with the first question of, is it illegal for an asset owner not to maintain their WSUD system? Over to you, Lauren.
Great, thanks, Daniel, and good to be with everyone today. So yes, as Daniel's introduced, I was part of a team at Clayton that looked at questions to do with management or maintenance of WSUD systems. I was part of the sort of New South Wales team looking at that, and I'm a New South Wales-based environment and planning lawyer. But there were also members of our team in Victoria and Queensland that inputted into this review, and so I'm going to be running through some of their findings as well. So yes, this first question, is it illegal for an asset owner not to maintain the WSUD system? In looking at this particular question, we approached it both from the perspective of a public asset owner, namely councils, but also private asset owners. And what we found, broadly speaking, from our review is that there were sort of two categories or two situations where it may be unlawful not to maintain a system. And that's where there's a direct obligation to maintain the system, and that might be expressed in a development consent condition for a particular development. It may be expressed in New South Wales in a positive covenant applying to the system or land, but in other states, there are particular agreements that apply to these systems. But it also might be expressed in the legislation to have a mandatory obligation to maintain the system. And the second category was in circumstances where the failure to maintain a particular system has led to the commission of an environmental offence or environmental harm. And so there's sort of the two kind of broad categories where it may become unlawful for failing to maintain a particular system. I will need to note at the outset that our review was high level, and it's whether something leads to the commission of offence or whether something is a breach of a development consent condition or a legal obligation is highly fact specific, and it's also state specific. So I'll just note that to start, that really our review was trying to identify what are the potential issues that might arise here. So if we move firstly to New South Wales into the next slide. So as part of our review, we firstly tried to understand whether there were express obligations for maintenance applying in New South Wales. And when it came to public WSUD asset owners or system owners, the focus was on local councils and their ownership of their assets. We couldn't find an express mandatory obligation in the legislation itself. What we could find under the Local Government Act is that there are particular powers for councils in operating and maintaining stormwater drainage works. So for instance, councils are owners of stormwater drainage works that are installed on land, whether they're the owner of land or not. And they have powers to operate, repair, and maintain these systems to ensure that they're operating in an efficient manner. However, the definition of stormwater drainage work may be quite limited in the sense that it applies mainly to stormwater drains communicating with stormwater channels. And so whilst that might extend to WSUD assets, depending on the system involved, it may not as well, and it may not be relevant to a particular WSUD system. But in the legislation itself, it dealt with powers, but it didn't have an express mandatory maintenance obligation. And that was similar when we were looking for private WSUD assets. There wasn't sort of a broad ranging legislative obligation that said expressly you needed to maintain the WSUD system. However, those sorts of obligations when it comes to private WSUD asset owners are mainly expressed in the development consent conditions. So you'll see there that it would be unlawful or a breach of law if a development owner had a development consent condition that required maintenance of the particular system, whether that's a broad-ranging obligation to make sure it's in efficient and working order, or whether that might be requiring compliance with a maintenance schedule. That could be a breach of law, and we've outlined there some of the enforcement actions that might be taken against a private WSUD owner if there was a breach of development consent. So in New South Wales, that might include a council issuing a development control order to compel compliance, civil enforcement proceedings, criminal proceedings, or the issuing of a fine. So there's sort of those mandatory obligations. If we turn then to secondary consequences, so if, for instance, the failure to maintain a particular system led to environmental harm and an offence, that could also be unlawful. And what we've outlined on the slide there are two potentially relevant offences in the Protection of the Environment Operations Act in New South Wales. The second is causing water pollution. So that's under section 120 of the Act. And basically it's an offence for a person to pollute waters, and pollute waters includes causing or permitting that pollution in waters. It's a strict liability offence, which means that you don't need to prove the mental element of the offence. And then the first offence that we also outlined was the offence under 116 of the Protection of the Environment Operations Act. And that's an offence where someone willfully or negligently causes a substance to leak, spill, or otherwise escape in a manner that harms or is likely to harm the environment. Now, we just raise these two potential offences because they may be relevant if a lack of management or maintenance of a system leads to water pollution or environmental offence of this nature. The 116 offence may be more difficult to establish, namely because there is a mental element that's required as part of the offence. So a person needs to willfully or intentionally commit the offence or negligently. And in order to do so negligently, there needs to be established a duty of care in that particular circumstance. I will note also that it's a defence to these what we call tier 1 environmental offences, where a person can prove or demonstrate that the commission of the offence was due to causes that were outside of their control, and the person took reasonable precautions or exercise of due diligence to prevent the commission of the offence. And in circumstances where a person hasn't properly maintained a system, it may be difficult to establish that defence is applying. So that's really what I need to say on New South Wales. So we might move to the next slide, which is Queensland. And again, we set out first looking for an express and clear obligation to do with specifically WSUD systems or assets. And we couldn't find that necessarily in the legislation. Again, when it comes to private WSUD assets, the breaching of a development condition that applies is the most logical way in which someone may unlawfully maintain a system, is whether they have a mandatory requirement or express requirement in that condition. And we've just noted there on the slide the penalty that might apply in that case. But in Queensland, they have a general environmental duty which may be relevant to consider in these particular circumstances. So the general environmental duty is under their environment protection legislation, and it prohibits any person from carrying out an activity that causes or will likely cause environmental harm unless they take all reasonable and practical measures to prevent or minimise the harm. Now, that duty applies to all persons in Queensland, including councils, and a person in the carrying out of an activity can cause or likely cause harm both directly and indirectly. Now, in Queensland, it's not actually an offence to breach the duty per se, but a breach of the duty may lead to environmental harm being caused, and there are offences there for causing that environmental harm. So I guess the question with the general environmental duty, or the issues that need to be considered, is that it's expressed to be generally applying. And so in the context where there's a failure to maintain a system, there's an open question to be asked as to whether an omission or a failure to do something might actually constitute the carrying out of an activity for the purpose of the general environmental duty. So in circumstances where perhaps a council owns an asset and leaves, let's say, the infrastructure, but it isn't necessarily part of its active operations or within its land, for instance, it may be difficult to argue that an omission or a lack of doing something might engage that general environmental duty. But certainly if a failure to maintain a system has actually led to environmental harm, then it might be that these environmental offences become relevant. And so Daniel's actually outlined on this slide an offence that may be relevant in these particular circumstances, and that's the offence in 440ZG of the Environment Protection Act. And that particular section makes an offence and says that the person must not unlawfully deposit a prescribed water contaminant in waters or in a roadside gutter or stormwater drainage, or at another place in a way that the contaminant could reasonably be expected to wash, flow, fall, or otherwise move into waters, a roadside gutter, or stormwater drainage. And then there's also another offence where a person unlawfully releases stormwater runoff into waters, a roadside gutter, or stormwater drainage that results in the buildup of earth in waters, a roadside gutter, or stormwater drainage. And so we've identified those offences as potentially relevant to this area and something to consider. Obviously, whether lack of maintenance or a particular action leads to this offence is highly factual, as we've talked about, and so that would need to be really considered in the particular circumstances. So let's move on to Victoria. And again, we've got the breaching a development consent condition that is mainly for private asset owners. The clearest obligation we see is usually within a condition of consent. And if there's a breach of that condition, there are enforcement actions available for the regulator, mainly councils, against that person to try and compel compliance. When it comes to generally speaking under the Victorian legislation, we also have a general environmental duty applying. Now, the Victorian environmental protection legislation went through really a whole-scale reform with a new act coming into effect on the 1st of July 2021. That introduced a general environmental duty, and that applies to positive acts or activities to ensure that people are reducing the risk of harm to human health and the environment from pollution and waste. So that's sort of the intention of the duty. And so section 25 of the Act says a person who is engaging in an activity that may give rise to risks to human health or the environment from pollution or waste must minimise those risks so far as reasonably practicable. And what is reducing the risks could mean the elimination of the risks if that's possible, or reducing the risks. And what is reasonably practical in the particular circumstances depends on a range of things, including the likelihood of the risk, the degree of harm, the costs, the methodologies that are available. So as I said, it's highly factual and highly specific to the circumstances of the particular case. But if someone breaches that duty, there are civil penalties that apply, but there are criminal penalties that apply in specific circumstances. And that is, the criminal offence is if a person is to breach this duty in the course of conducting a business or an undertaking. And you'll see on the slide, we've included the penalties that apply to the criminal provision in these particular circumstances. And section 25(4) of the Act actually outlines an example where it might be held that a person has breached the GED and breached this criminal provision. And the example given is that a person fails to, in the course of conducting a business or undertaking, as far as reasonably practicable, uses or maintains plant, equipment, processes and systems in a manner that minimises risk. So there's a few things to consider with the GED. One is that it doesn't actually require environmental harm to take place. The duty is in respect of how you're carrying out the activities. And it is a strict liability offence. There's no mental element to it. So if we apply it in these particular contexts of public and private asset owners, when we talk about private owners, it perhaps more clearly applies to commercial operators, because we know that the criminal provision to breach the GED, it applies in the course of carrying out a business or an undertaking. So where a WSUD system is part of those commercial operations and commercial premises, it may be more likely, I guess, to apply in that context. Whereas we know from some of the explanation of the legislation that the criminal provision wouldn't apply to a domestic situation. So it wouldn't necessarily apply to residential premises. The GED would likely the sort of base duty, but in terms of the criminal provision, it wouldn't. And when it comes to councils and whether their failure to maintain might breach this GED, it's really on a case-by-case basis, and there's similar, I guess my colleagues in Victoria raised the similar question, that is the GED applies in the engagement of an activity. And so there's a query as to whether council just purely owning an asset may actually enliven the GED, as opposed to where it might be actively engaging in an activity to do with that asset. So that's sort of an open question and something that perhaps hopefully we might get some more clarity on in the future. I think it's worth saying with Victoria that the position used to be more clear, I believe, under the previous legislation, because under the previous Environment Protection Act, there was a state environment protection policy, waters, which applied, and it did actually apply under the new Act up until fairly recently. And that in that particular state policy, there was a mandatory or an express requirement that the owners and managers of assets to protect water quality were required to ensure that those assets were designed, managed and maintained appropriately for the purposes for which they were constructed. So there appeared to be like quite an express and mandatory requirement to maintain systems of this nature. Whereas now that no longer applies. And as early as early May this year, there's actually been an order made under the Act, and that order is entitled Obligations of Managers of Land or Infrastructure, Urban Stormwater Management and On-Site Wastewater Management. It was gazetted on the 7th of May this year. And in it, we don't actually see the same mandatory obligation that was under the state policy, but there is a requirement for councils to prepare stormwater management plans. And in those plans, there's a requirement to identify the risks and actions to minimise the risk of pollution in urban stormwater settings. And so we might find that what councils are required to do in order to minimise the risk of pollution and waste is actually articulated in these particular stormwater management plans. And there might be people online in Victoria that might have a bit more familiarity with that new order and those plans. So we'll just move on quickly to that second question. Thanks, Daniel. And so the question 2 was, is it illegal for councils not to enforce maintenance requirements on private WSUD systems? So council, I guess, as regulator, is it unlawful for councils to fail to enforce particular requirements? And really the answer across jurisdictions was no. The council has a discretion as to what enforcement action it takes. It is not obliged to take enforcement action against every single breach of a development consent, for instance. And these decisions are discretionary. They're based on a number of factors. But the council, in deciding what enforcement action to take, will often consider, the role of council, its objectives and functions as a regulator. It will take into account its enforcement policies and where it's appropriate to take action. But it'll also need to understand and consider, well, what is the impact of failing to sort of enforce these requirements? It's worth noting before I hand over to Daniel to consider this third question that in our review, we didn't look specifically at the question of a duty of care. So we didn't look at whether the council had a statutory or common law duty of care in respect of WSUD systems. So the question as to whether a private individual might sue the council for a failure to maintain a system alleging that they had a duty of care and that they've breached their duty of care and caused harm to them, that's an open question, and that particular area is very complex and highly factually specific. So I'll leave it there and hand over to Daniel to consider this third question.
So that's Aaron. So with this third question, it's about the mechanisms that can be used to allow councils to require certain things to be done during, but also after development projects that have WSUD systems on them. And so with this, there are a few things that kind of came out of the review that Clayton Utes did, which was one thing to consider was planning controls. So there are development control plans, local environmental plans, and other controls and plans that councils can use to enforce these requirements during and after development. And so, for example, Blacktown City Council has their Blacktown Development Control Plan, Part J, which has requirements around maintenance contracts and maintenance schedules and positive covenants. And that, so a development needs to be in accordance with Part J and it needs to be meeting those requirements. Next, there is also development conditions. So these can be imposed during development, but also, as kind of Lauren mentioned, it could be also post-development as well. And so this could be requirements to have maintenance schedules put in place, for maintenance to be occurring throughout the life of the development, to have agreements put in place so that maintenance does occur later on. And then going off that, the WSUD system agreement. So the terminology varies between states. In New South Wales, it's positive and restrictive covenants. In Queensland, it could be a covenant or it could be an easement. In Victoria, they're called Section 173 agreements. So I went with the terminology of a WSUD system agreement, which is basically an agreement in place between the council and the asset owner, which is that the asset owner will be maintaining and looking after that system in perpetuity. And so if you look at, for example, Blacktown City Council's standard recitals for this, in the engineering guidelines for development, it talks about how the owner has to be maintaining the system, needs to be reporting on it, and to do certain things, including allowing council to actually have the ability to enter the property to inspect the WSUD system. And so that is something to kind of look into. And if you're interested in more about these development conditions, there are some proposed ones within the guideline that comes within the framework that I've worked on. And then there's also a bit of information about WSUD system agreements there if you're interested on more stuff there. And so just kind of summarizing this presentation, because we're near the end now, but basically, as kind of Lauren highlighted, it can be illegal not to maintain if it is causing environmental harm and or if it's required by a development condition, a WSUD system agreement, or some sort of obligation through legislation or something else requiring that maintenance to be happening. And the consequences will vary depending on the context, but can be significant. For example, with New South Wales, with the POEO Act, there is the potential maximum penalty of $10 million. So that can be quite significant. And so that is, yeah, really depending on that situation. And following all this, I would highlight that council really need to be thinking about improving management of WSUD systems. This is something that the industry has been struggling with for a long time. And so this is something they need to be looking at and looking into. And that is where the WSUD maintenance compliance framework comes into place. You can get access to it right now. You can search the URL in the top right-hand corner or scan the QR code and it will take you to it. And you can look up this information and resources and tools and see what your organization can do to improve the management and implementation of WSUD assets within your jurisdiction. And this project is going to continually evolve with time, and more is going to be added to this. And so if you're interested in hearing a bit more about that legal information, looking at development conditions, or looking at how to operate the program, this is where you should kind of look towards. Just some reminders before we get into Q&A. If you do have questions, if you can put them in the Q&A panel and not the chat, it just makes it a bit easier for us to manage that. If you're interested in the slides and recordings, they will be available on the Ocean Protect website, so on the webinars page. And then if you're looking for CPD, they can be requested via inquiries@oceanprotect.com.au. And so that is the end of the presentation. Our contact details are on the screen, emails, phone numbers, and you can scan the QR codes to connect with us on LinkedIn. Alternatively, there is the QR code at the top, which will give you access to that framework if that's where you want to have a look at. I do want to say thanks to everyone for coming along today. There's been over 250 people on today's webinar, so that's really appreciated. I also want to say thanks to Lauren for coming along and sharing your knowledge in this space. Before we get into Q&A, is there anything you want to add, Lauren?
No, I think let's crack on and get into the questions. I think we can explore some more themes there.
So Brad, do you want to?
Sure, I can do, Daniel. I don't want to steal your thunder, but
no, that's fine. You read it for us.
Cool, great. All cool. Look, we've had a lot of questions come through already, so thank you very much. We'll try to get to each one as best we can. First in, best dressed generally, but if you do have any questions, please put them in the Q&A panel. And I can see I've got about 14 already, so we'll charge through. Craig Norton was very early. Craig Norton asks, if consent conditions don't expressly talk to a WSUD system in a development, can a condition be added or clarified retrospectively?
I can take this one, and we'll speak from New South Wales experience primarily. So, I mean, development consent conditions are really, and why it's so important to indicate these requirements early on is that I'm unaware of council being able to impose new conditions on a development consent outside of a particular application. So it may be that a particular development submits a modification application, and consideration of the conditions with respect to a WSUD system asset is a relevant matter as part of that modification application. That might present an opportunity for the councils in assessing that particular application, to impose some further or clarify some further requirements. But I'm not aware of New South Wales councils or consent authorities being able to impose conditions outside of applications. Now, that is different from if we talk about environment protection licenses, if you're familiar with that, and I'm not saying that that's relevant to WSUD necessarily, but the New South Wales EPA has a power to basically vary a licence itself and through notice to the particular applicant, where that's not necessarily the case when it comes to development consents, which is also, a good opportunity, as you know, Daniel outlined, that these sort of requirements can be imposed through planning controls, through the assessment of development application, through conditions of consent. It's another reason why having these matters dealt with when the development application actually comes through the door and is assessed is actually really important. So I hope that answers that question.
No, thank you. Thanks, Lauren. That was great. The questions keep coming through. We've got one from James Lenhart, the godfather of stormwater in Tucson, Arizona in the US. So grateful for your presence, James. James asks, how is harm to the environment defined and measured?
James, look, thank you for your question. I don't have the definitions at hand with me, and it's really really dependent on the particular provision we're talking about. So we've been talking about 3 different states, 3 different acts, and how they define environmental harm will be different under that particular legislation. So apologies that I can't provide a specific definition for you now, but in terms of how it's measured too will perhaps depend on how it's defined, but may need expert evidence to demonstrate that there's been harm to the environment. Certainly, if there's an offence being prosecuted, will be reliant on evidence gathered by environmental officers or other experts as well.
Cool, thank you. Another question from Jeff Rabbage from Moreton Bay Regional Council, team leader at Stormwater Quality there. Thanks for coming along, Jeff. Jeff asks, does the lawful requirement to maintain, e.g. a stormwater drainage biobasin, transfer to a new owner or owners of a private property?
I can comment on 2 aspects of this, really. So if there's a requirement in a development consent condition to maintain this particular biobasin on that particular property, that condition will apply to future owners, because development consents run with the land. So if a future owner is relying on a development consent to carry out its development, whether that be residential, commercial or industrial, those obligations apply to a future owner. And then also, I mean, I know briefly, just in terms of those agreements that Daniel was touching on, they are registered on the title. So a new owner will be, well, if they're doing their due diligence, they'll know that there's a particular restriction that applies to that land. So there's I guess the design of both of these sort of instruments is that it will regulate future owners. It doesn't just stop with the current owner when they transfer title.
Cool, thank you. Another question from, I think, Ben Peneleric from Ipswich City Council. Question for Lauren. Ben asks, in Queensland, we have the stormwater quality management requirements in our state planning policy, which are either met by implementing WSUD systems on private properties or on council-owned land. The stormwater quality management requirements are statutory. It is generally understood that in order to meet performance targets tied to the statutory requirements, the assets need to be maintained. If they're not being maintained, does this mean the statutory requirements are not being met? If so, what is the consequence of that? One question, sorry.
Yeah, I just can't really see that question written down in this Q&A, so I'm struggling with that. But perhaps, Darryl, you can help me out here. So is really the question that if there's statutory requirements to maintain and they're not being met, are there breaches and what are the consequences of that?
Yeah, Brad, I didn't.
Yeah,
can't
if
see
you
the
see in the
question,
tab,
sorry.
it's actually listed under the answered tab.
Oh, okay, yeah.
It's listed as anonymous attendee, but Ben's confirmed it was his question.
Yeah.
So I'll just repeat it.
Thanks.
In Queensland, we have the SPP targets, which are met by putting assets on private properties or council-owned land. These are statutory requirements. It's obviously understood that you need to maintain the assets to meet these statutory requirements. But if they are not being maintained, does this mean the statutory requirements are not being met? And if so, what is the consequences of that?
Yeah, look, thanks for the question. I'm not familiar with the particular state planning policies in Queensland, but as a basic sort of response to that is if it is being expressed as a statutory requirement in these planning policies and it's not being met, it would be a breach of those policies, but I'm not particularly familiar with those state planning policies in Queensland, so I can't really comment on what the consequences would be under those particular instruments. It would depend on the particular powers expressed in either that policy or whatever the I guess overarching act under which those policies occur.
We might move on to another question. Some of them are very, very long. I might go to, gee whiz, I might go to Jeff Babbage's next question, if you like, Daniel. Apologies, this is a long question as well. I can appreciate I'm going to read it out now for everyone. I can appreciate the PO-EO Act and others that can be applied stringently. In general, water-sensitive urban design structures are installed to treat stormwater with chemical and physical constituents, like urban nutrients and suspended sediments, rather than acting as a wastewater treatment plant, treating complex wastewaters with the potential to cause material and environmental harm. If the inflow is that hazardous, WSUD might not be applicable relative to a purpose-built wastewater treatment system. Failure to maintain water-sensitive urban design assets might not lead to a breach given the nature of the inflow, or more difficult to prosecute relative to not maintaining a wastewater treatment plant with a hazardous inflow. This is a general comment though, but keen to get either of your thoughts as well.
Well, yeah, I guess in terms of managing stormwater, it is going to vary from property to property. Different pollutants are going to be generated based off the land use, the type of property, the catchment and everything. So that kind of does, make it hard to make something very clearly apply to a particular instance. I'm not too familiar with, I guess, wastewater treatment plants. That might be something Brad's a bit more familiar with. But yeah, I don't really know what else to kind of add to this. But yeah, there are points in this that make sense.
Look, I can try to provide a comment. It is a comment from Jeff, and it's a good point. I used to operate a wastewater treatment plant, a poo farm, otherwise known as. I reckon stormwater is way more difficult, way more complex. I completely disagree with any proposal that wastewater's simpler. Or is more complex. Sorry, wastewater is far more simple. Flows almost constantly, diurnal fluctuations, and that's about it. But stormwater, droughts and floods, a real diversity of pollutants. They're obviously in place to stop stormwater pollution, which is recognised as being highly damaging and is the leading cause of ecological degradation in our urban waterways and plastic in our oceans and waterways. Do not agree that it's not hazardous, basically. So it's a good point, but I think it's an equally important thing to try and manage appropriately. Another long question, unless Lauren or Daniel wanted to add to that at all. Cool. Shakings of head. Okay. Jeremy Weiner asks, WSUD by their nature use vegetation for stormwater control, bioretention, erosion control, biodiversity, and heat island mitigation. I've seen many instances of landscape maintenance practices using herbicides to control weeds in WSUD. Evidence is available that these herbicides affect the bioretention ability of the water of the WSUD by killing a range of beneficial soil flora, which are important for improving water quality. Additionally, the herbicides can directly or indirectly cause environmental harm as they are easily translocated in water to downstream environments. In the context of WSUD maintenance, is the use of herbicide toxins a potential breach of the Environmental Protection Act and the POE Act? Is their use a breach of the owner's duty of care? Great question. Long one, but good.
Yeah, that's a long question. Yeah, well, I guess I'm not too familiar with all of this stuff, but I think the reality is if you're not doing maintenance or doing a poor job of maintenance, and that if either of those are causing environmental harm, that the POEO Act would apply to that. So I think there could be potential for that, if it can be shown that that herbicide has left that asset and caused environmental harm. Brad is more of the buyer retention person, so maybe he has a comment on that, or maybe Lauren wants to comment on that as well.
Oh yeah, it's a really good question, and I guess it just shows how complex the issues can be in terms of what constitutes an offence and what part of lack of maintenance, or in this case, is it actually the act of maintaining a particular part of the WSUD asset that may cause environmental harm. I can't answer without the particular circumstances, of course, but yeah, it's a relevant consideration whether the use of pesticides or the use of chemicals may actually lead to some of those offences we're talking about of leaking, spilling, escaping, or polluting waters. So yeah, it's a good question to consider.
For what it's worth, I definitely think it's illegal, but I'm not a lawyer. We've got a shorter question, thankfully. Next question is also from Ben Penalert from Ipswich City Council. Ben asks, Lauren, is a question for Lauren. Given your understanding of the WSUD systems and the law, do you think there are sufficient legal requirements to ensure public and private owners are maintaining their systems?
Yeah, that is a really good question, Ben. Thank you for that. Yeah, I think what was interesting perhaps in our review is that it's hard, and what you've probably surmised by the presentation is it's hard to hang your hat on the general legal sort of requirements, mainly because they're not necessarily specific to these WSUD assets, for one, and two, you're relying on kind of broad breach or duty provisions, and it's highly factual. So it's not necessarily clear, I guess, in general legislation, but it highlights the importance of protection within planning controls for developments, I would say. And I think I've touched on this in the answer to another question. What we really realised from the general review is it's actually the devil's in the detail of the design requirements in the planning controls when you put your development application in, on requiring, consideration of these particular issues of designing these assets in a proper manner, in ensuring that maintenance obligations are in those development consent conditions or in those agreements, because it's not only, but perhaps more clearly expressed in those conditions that apply to particular land and a particular development. And if those obligations are up front for a particular person operating a development or carrying out a development, it makes it easier for them to adhere to, let's say, but also much easier for regulators to be able to try and compel compliance with that maintenance. So I would say, I'd say that there probably is room for there to be, I guess, clearer obligations in legislation if that's appropriate. But I guess the way that that councils, let's say for private WSUD asset owners, have tried to direct the obligations is in the development consent conditions. And I think the focus is really ensuring that councils are really, I guess, cognizant of the need at a design and development consent stage to really make sure that that maintenance requirement is robust.
Cool. Thank you, Lauren. I'm going to go to another short question if I can. Catherine Hawken from Blue Mountains City Council, the program leader for development engineers there. Thank you for the question, Catherine. Catherine asks, the New South Wales SEPP exempt and complying development has standard conditions requiring a covenant to be created over an on-site detention system, but not WSUD measures. It might be worthwhile approaching the New South Wales Department of Planning to see how these could be potentially included.
Yeah, I think now that this framework that I've been doing is publicly available as a consultation draft, I am going to be reaching out to councils, but also looking at kind of state departments and other organizations that are relevant to this. So that is a conversation that I'm hoping to have at some point. It hasn't happened yet because it's a lot's been going on, but I would be interested in talking to the Department of Planning and all the other relevant departments soon.
Yeah.
Yeah, that's a good suggestion to kind of work your way through how can it be imposed on I imagine that's complying developments, particularly in New South Wales, where there's an emphasis on trying to sort of funnel some developments through the complying development pathway. I will note that as part of this review, I think we saw that the New South Wales Department has sort of standard conditions. I'm not sure how widely they're used, to be honest, but they had a standard condition which required some level of making sure that stormwater assets or stormwater systems are used efficiently. It's quite a sort of simple condition, and certainly doesn't reflect the kind of robust sort of system that Daniel and Ocean Protector are putting out there. But there may be some room also for engagement with the department about guidance at a broad level about the kind of conditions that could be used in these circumstances.
Cool. I know Chris Gray from GEMS has been very patient. Greetings, Chris, longtime friend of the stormwater industry. Chris asks, did you guys look at the potential for regulatory authorities to serve a prevention notice, I think under the POEO Act in New South Wales, that can be served for environmentally unsatisfactory behaviour, which not maintaining treatment systems certainly would be. This approach would mean regulatory authorities do not have to wait for an offence to occur or be likely to occur. I think you might have touched on this briefly, Lauren, but maybe Chris might have missed it.
Look, we didn't explore all of the enforcement opportunities that could happen in terms of offences or potential offences. So really our focus in terms of private WSUD assets was really in the planning space. We have outlined that obviously failure to maintain can lead to environmental harm, and these are factors that need to be considered, but our review didn't really go into the detail as to what action could be taken under the POEO Act, particularly by the EPA. The focus, I guess, was mainly on councils, but there's certainly a suite of regulatory action and potential for the EPA to get involved if it was causing environmental harm, or it triggered the ability to issue a prevention notice or to issue other notices in instances where the EPA might be satisfied that particular conditions are likely or have happened. The particular provision of the POEO Act would need to be satisfied. But yeah, there's certainly, if it's causing environmental harm, there's a whole suite of sort of enforcement action that can be taken by the EPA arm and councils acting as an appropriate regulatory authority. But the focus, I guess, was really, were there express obligations in the context of development? Yeah.
Cool. Thanks, Lauren. Probably a comment and a question, or comment and a couple of comments from Paul Dabowski. So Paul's from Queensland Urban Utilities. So greetings, Paul. Real diverse audience today. Paul's commenting around the question around wastewater and whether how polluting it is relative to stormwater. And he's reminded us that in one study, they found that annual sediment ammonium flux in Moreton Bay is 180 times larger than the region's point source inputs, and basically says, yeah, stormwater is a massive source of pollution. But he also brings up a point around the keeping the legislation up to date. And obviously, this study was done a little while ago, but he raises the point around some of the legislation, at least in Queensland, might be a little bit outdated already. Since you've done this work, and I know we've talked about this, Daniel and I as well. But Paul's comment, I'll just read it out. He says some of the information presented for Queensland is a little bit out of date. Recent changes being brought in under the Environmental Protection Bill are highly relevant for water-sensitive urban design maintenance, and include number one, there's a new general environmental duty offence which can be applied if someone fails to take reasonably practicable. Previously, it was called reasonable and practical action to prevent or minimise material or serious environmental harm. Without the emphasis on reasonable, asset owners will no longer have a defence to avoid foreseeable maintenance requirements. Number two, he says environmental nuisance can be considered material or serious or a material environmental harm now. There's now an inclusion of a duty to restore the environment as well. And number four, environmental values now include public health, safety, and sense of community, in addition to the traditional ecological and amenity EVs. I'm not sure if you guys wanted to comment on that about.
One thing I would add here is, so with the framework that was released in April, there has been a few changes to New South Wales, to Queensland and Victoria now. So when I go to update the framework at the end of the consultation period, which ends in August, I will be looking to try and include these updates. So that's helpful to have that, and I can look and incorporate that. But yeah, so the law is always kind of changing, and I'm sure Lauren can talk to that. But yeah, thanks for kind of sending that through, Paul, and I'll keep a note of that.
Yeah, thanks, Paul, for that comment. I'm not, as I don't practice in Queensland, I'm not aware of that bill, but definitely something to keep an eye on, that there's continual sort of improvement and clarifying, the G&D and these obligations. So yeah, Daniel will be across it for the next draft.
Cool. Might dive into another question. It's from an anonymous attendee. We don't generally like these ones because we do like everyone to say where they're coming from so we can manage any potential conflicts. But they ask, what can council engineering, what can engineering in council do to improve current position to avoid on-site water-sensitive urban design at all costs due to the lack of maintenance by future owners? We currently don't require full compliance with the Vic planning scheme, clause 53.18. No water sensitive urban design offset payments scheme either, and no DES water quality contributions in some Melbourne Water DSS as well.
I might say some stuff, and then Brad, you might have something to comment on this.
No, please.
Yeah, like I think the thing is, on-site and off-site, or whatever you want to call it, has there's pros and cons for both. So I don't think you should look to avoid something at all costs. There are issues trying to enforce this compliance on private assets, but then councils have issues and struggles with managing their own public assets. So I think it's a bit of a balance in trying to find out what works for that council. It's going to be different for each council, but I think that one particular approach shouldn't be completely avoided. But yeah, I'm not too familiar with the Victoria planning scheme and Melbourne Water and stuff, so that might be more of a Brad thing that he can comment to. But
look, I'll try. I don't look, very quickly, I don't want to steal the amazing expertise that Lauren and Daniel bring. The proposal to avoid on-site water at all costs is fundamentally flawed. If we're serious about protecting and enhancing, or at least preserving even the health of our waterways, we have to do so much from a total water cycle management perspective to appropriately protect our waterways. So that includes stream bank vegetation, end of pipe solutions, and at source treatment, and also mitigating the generation of pollution as well. Without any one of those things, we will not achieve the appropriate protection of our waterways, which is mandated under most legislation. So just don't buy that at all. And I find if you don't do on-site treatment or do offsets or whatever, you're putting far more risk into downstream environments, and putting the responsibility on people or groups that often don't have the resources to do it appropriately. There's a comment there around offsets in Melbourne Water. Yeah, they collect about $200 million a year, I think, last year. I'm not sure where they spent it. I think they'd struggle to spend it appropriately and achieve environmental equivalence. Cool. Lauren or Daniel, anything further to add?
I'm all good.
Question, I guess, there's a lot of questions. Sorry, there's so many questions coming through. Apologies. Lee Bennett from DES chimes in around pesticides. It depends on, in terms of whether it's illegal or not to use it, it depends on the labour requirements of the chemical and its use. If you wanted to find a label or permit, there is a relevant APVMA website, Public Chemical Registration Information System search, and I'll include a link in that in the show notes and in the chat. Look, I'm struggling to keep up with these ones. If there's one that you see, Daniel, that really wants your attention, please let me know.
Well, I might add there's another anonymous one that I kind of wanted to touch on. So someone's asked, what are the proprietary device companies such as Ocean Protect and where'd the question go? And Atlan doing to ensure all new devices are being registered and maintained? We see more and more devices being installed, and unlike WSUD, these devices are hidden under the ground, and when they are forgotten about, surely these should be mandatory maintenance programs that should be included in the sale of these devices. So yeah, the proprietary devices are part of WSUD. They do help meet the goals and objectives of WSUD. So I think those are kind of with that. However, I think that, yeah, the difference here is they are quite hidden, so it can be easy to forget and not see them and not realize the impact that they can have on the environment and other aspects of the community. So I think with this whole framework, that is what I guess Ocean Protect are trying to lead and push for, that these assets are being registered by councils and then being kept track of. Ocean Protect has a list of where all our assets are in the country, and we can kind of help figure out that if councils want to know that. But I think with what we're trying to do with the framework is helping with this. There's a whole process about making these get registered within an information management system so that council would have a record of all the different assets, all the maintenance requirements for those assets, maintenance schedule being developed for all of those assets. And so that requirement is more on council to do. We keep a track of our assets, Atlan keep a track of their assets. However, councils are the ones that will need to be managing that information within their LGA. But that is what we're hoping can happen from this framework, that it leads to more of these assets being tracked and managed so that they're not being forgotten because they're hidden.
Cool. Another question from Hugh Hoyt. Good question. Can you guys speak to the legality of some councils allowing offset payments in lieu of meeting water quality outcomes within their planning controls? So a number of Queensland councils will basically totally waive water quality requirements or the need for water sensitive urban design assets if the developer just pays some cash. Does this raise any legal issues?
I'll leave that maybe with Lauren.
Oh, this is, yeah, look, unfortunately, Hugh, I really can't comment on that, not being a Queensland lawyer, but also I just avoiding offset and contribution payment comments in this presentation. So yeah, something to consider, but I just wouldn't be able to speak to it. Apologies for that.
It's all good. Chris Gray asked another question. For nearly all of their activities, councils in New South Wales are their own determining authority under Part 5 of the EP&A Act. Is anyone aware of a council that routinely imposes a maintenance condition of consent on their own stormwater management assets?
I'm not too sure of that. I don't think there really is councils imposing conditions on themselves requiring that. I could be wrong. I haven't interacted with every council, but I do know there are those requirements for private, and in public it is more up to a council to make that decision on doing that. Some might have covenants or agreements in place with another authority that could be requiring them to do the maintenance. But yeah, I think it would be interesting to have that in more of a condition of consent or an agreement such as a covenant requiring that from councils.
Yeah.
Yeah, look, I'm not aware. I'd be interested in understanding. I see that there's a comment that's just been made that you sort of Part 5 are more determinations or environmental assessments. And so whether there are active conditions that might apply is something to consider.
Look,
yeah, thanks.
We are flush out of time. It's been an amazing session. If you do have any further questions, or you did have some that you didn't get a chance to get answered by these amazing individuals, please reach out to either or. Their details are on the screen. Just a reminder, the recording will be made available on the oceanprotect.com.au/webinars website in a day or two, along with the slides. But obviously, you can reach out to either Lauren or Daniel separately. And on behalf of Ocean Protect, thank you so much for Lauren for giving up her time today. It was so wonderful to have a legal expert come along and give such great information on such an important topic. So thank you so much.
Thank you, Lauren.
All right, thank you. Been good to discuss. So.
And thanks once again to Daniel Ryder, legend, superstar.
Thanks, Brad. Thanks
Thanks,
everyone
guys.
for coming.
Thanks guys. Enjoy the rest of your day.
Thanks, everyone.